So the YSL trial has already been crazy for day 91. We have Brian Steele comparing the court to communist Russia, and we also found out that there was yet another meeting with the prosecutors and witness, Kenneth Copeland, aka Woody. So a lot of interesting arguments taking place in the courtroom today. But as far as the attorney sparring on paper, we also have this motion in limine that ThuggerDaily very quickly grabbed. Shout out to ThuggerDaily, they're so quick with this stuff. Let's take a look at it. Let's see what Chief Deputy District Attorney Adriane Love is saying here, and I've got two questions for you. One, what do you think about this motion in limine, just in and of itself? What do you think about the argument that's made here? And question two, which is my greater curiosity, what do you think about this issue being the issue that Adriane Love is raising in the context of everything else that's gone on this week? Let's take a look at what it says. And you can see at the top it was filed today at 11:04 a.m., so very quick, thanks to ThuggerDaily. The state of Georgia, by and through Fani T. Willis, District Attorney for the Atlanta Judicial Circuit, and the undersigned Chief Deputy District Attorney Adriane L. Love, hereby moves this honorable court to overrule, and that's capitalized, defendant's improper objections premised on the assertion that the state is asking a leading question, when the question propounded does not suggest the answer desired, but instead refers to the witness to the topic to be answered. Now remember, we are still in the prosecution's case in chief. So with their witnesses, it's direct examination for them. And leading questions are, something that you're able to do on cross-examination, but shouldn't be doing on direct examination. The defense has made several leading question objections throughout this trial. And even though some of them have been sustained, not all of them have been sustained, but let's see what Adriane Love says is the problem here. She is citing Riley v. State, which says that recognizing that the question, does the name Junelle Fudge ring a bell, posed by the state after a witness could not recall a name, was not a leading question. They also refer to Ely v. State, which says, stating, the fact that the question referred to the witness in the topic to be answered does not make it a leading question, and that questions may legitimately suggest to the witness the topic of the answer. In support of this motion, the state shows this honorable court the following. Since the start of this trial, counsel for the defendants have represented to this honorable court that questions posed by the state that refer the witness to the topic to be answered, for instance, quote, do you see Dolly in that picture? Or, quote, is Dolly wearing a white shirt? Are impermissible leading questions. Counsel for the defendants have repeatedly objected to such questions posed by the state, and in many instances, the objections have been sustained by this honorable court. As officers of the court, the state has a duty to present to the court applicable case law that governs contested matters that may arise throughout this trial. Accordingly, the state respectfully moves this court in limine to overrule all objections premised upon the notion that the state has asked a leading question when the question propounded does not suggest an answer, but simply suggests to the witness the topic of the answer and calls for a yes or no answer. We have Burden v. State here cited with underlines and bold, holding that the trial court did not err in overruling defendant's objection to the question regarding whether any money was demanded of the victim because it was not a leading question, as it did not suggest a desired answer, and instead simply called for a yes or no response from the witness. Respectfully submitted this 13th day of June at 11:04 a.m., signed by Adriane L. Love. So what's especially interesting to me is that motions in limine, you kind of usually see those before trial kicks off. Here we are in the middle of the trial, and we're in the middle of a very, very all eyes on deck week of happenings in this trial. And we have this motion in limine filed now focusing on what the state is saying is something the defense has been doing all throughout the trial, since the start of the trial back in November of 2023. The problem with leading questions sometimes is if the witness doesn't have any knowledge of something, but something is inserted within the question itself, the jury is now able to think about that thing that's mentioned in the question, even if the witness doesn't give any testimony about any such topic or personal knowledge of such thing. And on the flip side of this, previously, Brian Steele has filed a motion against Adriane Love, asserting that she was acting as an unsworn witness because of the way she was asking certain questions. And because of that, he wanted her to take the stand as a witness. That way, his client would have the right to confront her as an unsworn witness. So, swear her, put her on the stand, let us question her about these things that she's inserting in her questioning. And while I'm not going to go through all of today's testimony, we also get a weird question today that leads to the defense attorneys to call yet again for another mistrial. And for quick context to catch us up to where we are in this clip that I'm about to play, Woody began the day by testifying, he said whatever he needed to say to clear his name. This was the explanation he gave for testifying to something different yesterday compared to what he actually told police in 2015. And the clip we're about to watch is in regard to specific questioning about Woody going to the police department for an interview the day after the murder. And this is the question that we get.
In that January 11, 2015 interview, was Thug in that interview with you?
Was Thug in that interview with you?
When you went to go speak with Detective Thorpe on January 11, 2015, was Thug in that interview with you?
What's your basis?
Look at Love's face. She said.
Okay. Mr. Copeland, can you step outside for just a second? Ladies and gentlemen, jury, can I get you to step in your headquarters just for a minute, please?
So he's going to step out. And this was around 10 a.m. that this happened. I'm recording this at, it's 1:04 p.m. near me. This is East Coast. And this timestamp is 3 hours ago. So this would have been about 10 a.m. And we had this motion in limine come down at 11:04 a.m.
All right, counsels, please be seated. Our jury has left us and Mr. Copeland has left us. Mr. Steele.
So what is Mr. Steele going to
what's your
motion?
motion, sir? Can you come to the podium, please, sir?
My motion is that there is a 24-4-403 comment on pre-arrest silence under ORR versus state. I believe it's a 2019 case, but I'll get you the site if it's not. If you put in or and Mallory.
I'm familiar with or. I'll look it up, sir.
And Mallory's MALLORY. What the state did is they set up a series of questions, repeating the question that Mr. Copeland gets a call from a Detective Thorpe on January 11, 2015, morning hours, telling him, according to Mr. Copeland, that he needs to come down to the police department. Mr. Copeland is reaching out to people allegedly saying whether I come or not. He spoke with people who said, go down to the police department. The state then, for some reason, immediately says, well, did Jeffrey Williams come? That's after the state elicits, it's non-answered because the witness said he doesn't know, that Jeffrey Williams' stepfather's house is supposedly shot up that night. When you put that together, it is a clear indication that Jeffrey Williams should have, if he's involved since his stepfather's house is being shot up, then he's being accused and he should go down to the police and talk to them as well. There's no basis for that. The state knows that Jeffrey Williams wasn't called by the police, wasn't asked to come down and speak. Why in the world would any prosecutor anywhere in this nation at any time ask a witness whether Jeffrey Williams was there? Nobody would say he was there. Nobody asked him to come. All it does is plants improperly in the mind of the jury. Jeffrey Williams was not bold like a lion, like Mr. Copeland, and go face the police that night. I'm moving for a minute.
All right, sir.
That cut out. He said moving for a mistrial when he moved the mic. And here's the response.
Mr. Steele, if you give me the site for or if you can find it, please. What year was it decided?
Probably 2016, maybe 19.
It's or versus state?
It's state versus or. It came from the Court of Appeals of Georgia up to the Supreme Court of Georgia. And reversed our previous demarcation where the state cannot comment on pre-arrest silence. Two is whether it is too prejudicial versus probative. And here there's zero probative value because the true evidence is that Mr. Williams is innocent of any charge, never asked by the police to come down, and didn't have a reason to go down to, quote, clear his name. So now the jurors are left with the unbelievable impression that somehow Jeffrey Williams should have gone to the police department but didn't, and he hid behind Mr. Copeland. It's just outrageous. I mean, to me, that is, I've tried so many cases, this is just wrong. And the state inquires of this witness, knowing, no matter what the witness said, it's just, nobody's going to say. There's going to be a video played where Mr. Copeland's sitting in a room with Detective Thorpe. I mean, what a crazy thing to say. Was Jeffrey Williams with you when you went to the police? Why, what's the probative value of that?
Well, I'm gonna find out, I guess, so. Okay, all right. Thank you, Mr. And the citation for is 351 Georgia App 578.
No, look at the state.
That's state v. or.
Look at the state versus or in the Georgia Supreme Court. So the
All right.
Georgia case. I think big counselors already have this. So.
Get the date. All right.
Looks like it's gonna be 305 Georgia 729, does that sound right? What year? Like a 2019 case. Georgia Supreme Court.
Is that correct? 305 Georgia 729, is that correct? Yeah, I see it. Okay. All right. It is 305 Georgia 729. All right. Okay, first question is what's the relevance of asking Mr. Copeland about Mr. Williams?
Sure. Mr. Copeland is now stating to this jury for the first time a version of facts very different than what he told police on January 10th, 2015. On January 10th, 2015, and the state will be going into this, Mr. Copeland advised police, specifically I want to talk about what happened on Cleveland Avenue. Mr. Copeland repeatedly in 2015 stated that little D got into the car. The first time he said that little D first said they killed Nut. As his interviews proceeded over the course of 6 months, he eventually says to police that little D told him that they, and he was referencing Shannon, Mr. Kendrick, Mr. Stillwell, Mr. Kendrick, Mr. McMullen, all killed Nut. He is now saying today, for the first time, to this jury and to us yesterday, that little D and Shannon got into the car and little D did not say anything to him. And that now everything he said back in 2015, he just lied to get out of the trouble. So what we are doing is showing that back in 2015, none of these individuals were present none of these individuals are present in the room when he was speaking to law enforcement officers.
So she's saying that she was trying to make a case that he would have no reason to be intimidated during the interview with the police in 2015 because young Thug wasn't present in that interview, in that room.
And therefore now his story is changing when he has to now testify in court in front of these individuals. So this has nothing to do.
So you're not trying to get into pre-arrest silence?
Not at all, Your Honor. And especially on January 10th, 2015, Mr. Copeland speaks for the first time during that interview about Mr. Williams. But at no point is the state trying to get into any pre-arrest silence. It is solely to show that back then, none of these people were in the room with him. And he gave one version. And now when he has to testify in front of all of them, he's now giving a completely different version than he gave back then.
Mr. Steele, I'm going to overrule your motion for mistrial. I'll note it that you've asked it before the positive of the next question. And I'll make it a continuing objection, okay? Sir, did you hear me, Mr. Steele? Okay, all right. Anything else, Mr. Steele? Before I move on to Mr. Sharp?
I mean, you ruled, so
Okay.
appreciate the mistrial being wage. Yeah.
Okay, all right. Mr. Sharp,
On behalf of Mr. Stillwell, I just want to make it clear, I know the Harvey Rule is in effect,
It
but I
is.
believe just for the record, that the comment, because this is a RICO case, and we've instituted the Harvey Rule for a reason, but also specifically, this is a RICO case where the constitutional violations of one defendant affect all the rest of us. We are linked together, we sink and swim together in many ways. I am too moving for a mistrial for the same reasons that Mr. Steele enunciated, and I understand the court's ruling, but for the record, I just want to make it clear that I have specifically joined this motion on behalf of Mr. Stillwell.
I'll note that Harvey Rule is in effect and all counsel, it will apply for all counsel that you move for mistrial and that you posited another motion for mistrial before the positive the next question, okay?
Yes,
All
thank
right.
you, Your Honor.
Okay, anybody else? Okay, thank you. All right. Like I said, I'm gonna note it for all defendants present that you move for mistrial. All right. Unless there's anything else.
You consider a limited curative instruction admonishing the state in front of the jury that this has nothing to do with Mr. Williams, they should not have asked that question, and that the jury should take no adverse inference.
You can see Ms. Love shaking her head in the side.
No, sir, because it's a proper question at this point in time, given the state's rationale over your objection, okay? All right, anything else?
I'd like to use the bathroom. I can wait.
No, go ahead. I'll let you all take 5 minutes and bless you and do that. We'll be in recess.
So again, this all played out by 10:15 a.m. this morning, and we have that motion by 11:04 a.m. Do you think that motion limine was related to the request here for a curative instruction and or the motion for a mistrial relating to the argument about did young thug come down to the police station for an interview with you? And I do think that the prosecution came up with an alternative reason for why they asked that question, even though there's better ways to ask the question if that's what you're trying to establish. The question could have been, was anybody else in the room present with you during this interview while you were speaking and giving a statement to the police in 2015? Well, it's not 100% conclusive that that question was meant to shine a bad light on Jeffrey Williams, young thug, or if it was truly meant to demonstrate that, hey, we're trying to clean up the different stories that Woody is now saying on the stand, and we're trying to posit the theory forward to the jury that he's speaking differently now because he's intimidated by the presence of the defendants in the courtroom, where that wasn't at issue in 2015 when he initially made those statements. So there's the context that I suspect is the background for this motion in limine that we looked at. Do you think that this argument is related to this motion? Let me know any and all of your thoughts, and see you next time. Bye-bye.